Friends, we are quite glad to have with us on this episode of Liberty Dispatch interviews Lia Milousis. Lia is a member of the Acaica Group. Her practice focuses on constitutional law, administrative law, and human rights law. Prior to joining the Acaica Group, Lia was honored to serve as Associate Legal Counsel for the Christian Legal Fellowship. In that role, she assisted with multiple public interest interventions, including before the federal court, Quebec Court of Appeal, and Supreme Court of Canada. She was also involved in the publication process of Forgotten Foundations of the Canadian Constitution, a recent collection published in the Supreme Court Law Review. Lia earned her Bachelor of Social Sciences from the University of Ottawa in 2017, completing a joint honors degree specializing in political science and women's studies. She returned to the University of Ottawa and earned her Juris Doctor in 2020, graduating with a specialization in social justice. Lia was called to the Ontario Bar in 2021. Lia, thank you so much for joining us on Liberty Dispatch interviews. It's great to have you.
Thanks so much for having me, Andrew.
So the reason why we wanted to bring you on our episode is we wanted to increase exposure and bring some awareness to our audience, many of which may not be familiar with what's happening presently with the Christian Heritage Party in Ontario and some of the legal happenings there. So I'll just give you kind of full platform to let people know what is it, your involvement and connection, you and the Acaica Group with the Christian Heritage Party. What has led to this? What's some of the history behind this that brings us to this point? What's been going on in the armpit of Ontario that is Hamilton? At least that's what I call it because I'm from Ontario. What's happening in Steeltown right now and your connection with the CHP?
Yeah, for sure. So the history of this story really begins with an advertisement, and the advertisement was an advertisement that the Christian Heritage Party of Canada wanted to put up. And maybe I'll just take a step back actually and say the Christian Heritage Party, for those who maybe are not as familiar, it's a federal political party that's registered with Elections Canada. They run candidates in the federal elections. They have EDAs and they follow the standard process. So this is a political party that at this point has not been able to get a political seat, but they are part of the political and democratic process. So this is the framing that's really important for understanding the issues here. So the Christian Heritage Party of Canada is also, in the name, it's pretty clear that it's explicitly Christian. And so this is an organization, a political party that has as its aim, in part, actually advocating for Christian values. And that's going to be informed by the Christian worldview. And that's clearly outlined in CHP's policies and in its internal documents. And so the Christian Heritage Party has, at various points, faced difficulties in advertising, particularly in the city of Hamilton. And I say at various points, there was a prior case that was decided in 2018, where there was an advertisement that had been taken down unilaterally by the city after there was a CBC investigation and report because someone complained. And this was an advertisement that in the 2018 case drew attention to the fact that it was possible for biological men to enter women's spaces because they could self-identify as women. And so there was the image was of an individual entering, a man entering a woman's washroom. And the question was, about competing human rights and whose human rights would take precedent in a situation like that. So CHP has a history of engaging in democratic dialogue on this issue. And when I say this issue, I mean issues really pertaining to women's rights and to public spaces and the safety that is or is not there for women in those spaces. And that obviously is an issue that is now related even more so to questions of gender and sexuality. But really, this is about, from CHP's perspective, women's rights. So in 2023, the city rejected an advertisement that CHP wanted to put forward. And the advertisement was a simple image of a woman of color smiling, and it said, "Woman, an adult female." And I think, the messaging is one that is a little you can read into it a little bit, but it's not actually incredibly explicit. There are ways to communicate the idea, the core belief that CHP has that are much more explicit, much more direct. But this is a fairly gentle way of saying, woman and adult female. It's not really clear whether this is referring specifically to a biological female, a genetic female. It doesn't use any language that is explicit about gender and sexuality, but it does talk about sex and the definition of a woman. And so it's a simple dictionary definition. And this is the kind of thing that I think Canadians would maybe have views about, but wouldn't think is, hateful, discriminatory expression. But this advertisement was rejected by the city of Hamilton. And it was originally rejected by the third party that manages the city of Hamilton's advertising process. And it was rejected under the Advertising Standards Code of Canada. That is not a binding standard. It is something that cities often use as a guideline when they're approving or rejecting advertisements. And so the argument from the city's agent was that this advertisement violated the Canadian Code of Advertising Standards. The problem is that the Canadian Code of Advertising Standards explicitly says that it doesn't apply to political advertisements. And so from the very beginning of this saga, it was pretty clear that the original decision was based on a faulty premise. And that's something that the city has actually conceded in the legal process since then, that the Canadian Code of Advertising Standards doesn't apply to this political advertisement. But it was rejected on that basis originally, and that would have been in February. And then from February to July, there was this period where there were efforts from CHP and later from Legal Counsel, my former colleague, Alberto Polizagopoulos, who would make efforts to engage the city and ask the city to consider its decision, ask for reasons, push back, and just say, hey, the Canadian Charter of Rights and Freedoms actually applies here. As a city, the Canadian, the city has to respect the rights and freedoms of the Christian Heritage Party. And that's not just to Section 2B, which is freedom of expression and belief and thought, but also Section 2A, which protects freedom of religion and conscience. And so there was a dialogue or an effort to engage the city in dialogue. But what happened was essentially the city said that they would review the decision, and they went and did the review. It took several months, and then they released their decision. And in their decision, they explain a number of different things, but I'll just summarize for the sake of time. And essentially they say this could be offensive, this could be hurtful to individuals who want to use the transit system. This definition looks like a basic dictionary definition. They did concede that, but they said it had exclusionary undertones and it relied on a definition of woman that was associated with traditional and conservative values. And so it was pretty clear that the city was rejecting it, not because there was specific terminology or a specific image. They didn't take issue with the image itself or with any specific wording. They just didn't like the view. They didn't like the message that was being communicated. And that was pretty clear because they actually went to CHP's website and looked at some of their policies and said, see here, this is what you believe, this is what you stand for. And so that informs how we're going to read, interpret, and treat this advertisement. So this was an issue. A city can't just reject an advertisement because it disagrees with the message or the content. And this is a really important issue because this is a city, so a municipal government with its own political views, its own political bias, that is now preemptively censoring the views of another political entity, in this case, a registered political party, that is going to prevent democratic dialogue and discussion and discourse. And so the stakes that are present in this case are pretty significant. And so what happened is the Christian Heritage Party of Canada challenged this decision. They, one of the things maybe just just as an interesting note, is that the city did actually engage in a consultation process when it was reviewing the decision, but it didn't speak with the Christian Heritage Party of Canada. It didn't speak with women's groups. It didn't speak with any religious communities. It only spoke with the LGBTQ advisory committee that was part of the city's process or structure. And so, maybe just to be clear, there was not an issue with them consulting. The issue is with the unequal and inequitable way in which they ran their consultation. So they make the decision. This is then challenged to the divisional court. And so what the process, I could go into it in more detail if you're curious, but it'll be 3 judges that you present before. And so we challenged the decision of the city. And we said that the decision of the city was unreasonable. That's the legal test, is whether the decision was reasonable. And part of that consideration is the charter and the rights that were infringed. In this case, the infringement is very serious because it speaks to Section 2A, freedom of religion, but also Section 2B, freedom of expression. And this is expression that goes to the very core of what it means to be a free and democratic society. And so we brought this case to the divisional court, and the divisional court heard that case in October of 2024. And in November of 2024, they released their decision rejecting the application of the Christian Heritage Party. And so, put simply, they upheld the decision of the municipality and found that the decision had been reasonable, that the city had balanced the rights of individuals who are gender nonconforming and transgender, balanced the rights of those individuals with the rights of the Christian Heritage Party of Canada. And really, the emphasis from the city and from the divisional court, the argument was that that this advertisement would threaten and undermine the ability of the city to provide a safe and welcoming transit system. And so the argument was that by allowing this advertisement to be on select bus shelters, that this would threaten the safety and welcoming nature of the transit system, and that there would be individuals, specifically transgender and gender nonconforming individuals, who would then potentially opt out and not have access to those services. So the divisional court accepted that. They accepted that allowing this advertisement would threaten the statutory objective, the safety and welcoming nature of the transit system that the city of Hamilton has. And that at that stage, there was a third party that intervened, the Legal Canada, which is an LGBTQ2IASP plus interest group who obviously sided with the city and advocated for the ad not to be allowed. So this was how things went at the divisional court. And so we ultimately sought leave to appeal, and maybe just to not use legal terminology, we asked permission from the Ontario Court of Appeal to hear the case before the Court of Appeal. So there's a process to do that. You don't get to do it automatically as of right. You need permission. And in this case, the divisional court did actually grant us permission, which doesn't say anything necessarily about which side or which decision they'll reach, but it just means that they agreed that there was at least some question, some legitimate legal argument in terms of the facts and in terms of specifically the divisional court's decision and how things were decided at that stage. So that's where we're at right now, and I'm happy to speak about some of the nuances, but there's a bit of an overview.
Well, thanks. That's great.
It sounds. This is just my opinion, and you don't have to affirm, confirm, or deny. I'll let Matt kind of take over a question or lead, but it sounds to me almost as if they just want to punt this off. So we agree. Oh, and also we don't want to let someone else take the responsibility ultimately for, it should be, there's still room to, we don't want to be the ones to have to deal with it. That's what it sounds like to me, which is not totally surprising, at least in some of the cases and happenings I've seen in the last several years regarding constitutional issues where there's an element of, we don't want to be the ones, right? Even recently we'd covered the Tamara Leach and Chris Barber. It almost seemed as if the decision from on high was, well, we recognize they didn't break any laws. We recognize they called for peaceful gathering. We recognize they were willing to work with the city. However, we can't just let nothing happen. So here's a little bit of a slap on the wrist. It just seems like an unwillingness to draw a hard and fast line saying this is right, this is wrong, we will take this position. Seems like a little bit of passing the buck from people. That's just my opinion. I'm not an expert. It's just my thoughts. I could be right. I could be wrong. I'm probably right. Matt, your turn.
Yeah, well, so what really stuck out to me when you were giving the overview, Leah, was this the competing rights within this case. And to me, it's rather confusing that we have a well-articulated rights within the charter that are in section 2 that are the essential rights that all Canadians have, and they're very, well defined within the charter. And then you have on the other side, you have very loosely defined privileges or feelings, like when you talk about the advertisement, well, the third party manager of the advertisements for Hamilton, the ad actually strictly was not a violation, which they've had to admit, of their advertising standards. So they can't even use that as some sort of appeal to it. And then you have, what seems to be a blatantly partisan consultation process where they're appealing to avert activist groups for the LGBTQ plus rights, who are obviously biased in what their opinion are going to be. So you have kind of two competing things, like clearly defined charter rights, and then kind of vaguely ad hoc principles and feelings on the one hand. How is it that the divisional court chose to side with, a more ill-defined set of rights or whatever it is that they're describing it as, and then clearly defined charter rights? To me, that is very baffling. And I know you're a lawyer, you have to be careful. You're part of but help Canadians understand, because maybe they're like me, what's going on? This seems like an open and shut case. How is this even a question?
Yeah, yeah, I understand the confusion, and these cases can become convoluted because the way that they are often framed in the media, or the way that they would just be understood by your everyday individual, isn't necessarily how they're talked about in the case itself. So maybe to try to simplify it, in the case of a judicial review, the test is, it's about reasonableness. In this case, sometimes it's a correctness standard. We don't have to go into that, but the question is whether the state, so in this case, the municipality, so the city of Hamilton, whether its decision balanced appropriately, reasonably, its statutory objective with the rights, the charter rights that were violated. And so in this case, the question is, did the city of Hamilton, in its efforts to maintain a safe and welcoming transit system, did it disproportionately or unreasonably violate the rights, the charter rights of the Christian Heritage Party? Now, importantly, one of the errors that we say the divisional court made, and it will be up to the Ontario Court of Appeal to see whether they agree with us or not, but one of the arguments that we raise is that the divisional court didn't actually discuss or engage with our arguments around Section 2A, freedom of religion. And so what they focused on was the rights of transgender persons versus the expressive freedom, the right to free expression of the Christian Heritage Party. And that's important. Section 2B is an important protection, but it wasn't the only one that was at play. And so freedom of religion is also squarely at issue when you have not just a registered political party, but a registered political party that is informed by explicitly freedom of religion or religious expression. So this isn't just about political views, this is about political and religious views. And one of the principles in the charter is particularly with free expression, is that the more central the expression is to the core purposes of free expression, and those purposes are things like truth seeking, self-actualization, the democratic process, the closer the expression is to those core principles, the more protection it gets. And so in this case, we say that the city and now the divisional court should have given more protection to the freedom of expression than it did, because it didn't sufficiently acknowledge the centrality of this expression, the way that it went to the very core of why we have free expression in a free and democratic society. If you cannot engage in democratic discourse, then how do you preserve a free and democratic society? If it's possible for one city to have some advertisements, so some voters get some views, but then another city is restricting other views, and so now the voters in that community have less information, they're exposed to less ideas, that creates a patchwork of political discourse in the country. And that means that the views you have, your access to full democratic discussion, will change potentially based on your location. And so that cannot be the case. That can't be the standard. And so we have to have a really robust protection of free expression when it's political, but also when it's religious. And it goes to the very core of the individual's identity. So maybe to take a step back, the way that the interests of transgender individuals and gender nonconforming persons, the way that those come into play would be in the statutory objective portion. But what the divisional court did, and we say incorrectly, is it actually elevated the third-party interests of individuals like transgender persons to almost a quasi-constitutional status by equating them with the constitutional rights of Christian Heritage Party. And I'll just say, while it is the case that there are constitutional rights that transgender people have, and those fully come into play in other contexts, in this case, the Christian Heritage Party of Canada doesn't have a charter obligation to other people. The charter is a shield that protects us from government action, from government overreach. And so what's happened in this case, and it's subtle, so it might be confusing, but it's important to notice. What's happened in this case is that there's been a shift where the protection that was meant to be afforded to the Christian Heritage Party, now the charter is shifting and being used against the Christian Heritage Party. And the argument is that, well, allowing this advertisement would actually violate the rights of other people. But the Christian Heritage Party doesn't actually owe charter obligations to other people. The government, the state, the city of Hamilton owes charter obligations to the Christian Heritage Party. And so it can be a little confusing, but it's important to have those lines drawn very clearly. And I would also say, I've mentioned Section 2A and 2B. There's also Section 15 in the Charter is the provision that talks about equality. And one of the arguments that I've raised and that we've raised in our materials is, if there is going to be consideration of these broader charter, and kind of rights and considerations, if we're going to go there, which we don't need to, but if we do, then you need to also think about the fact that the Christian Heritage Party needs to have equal access to advertising space, the way that other parties, like the way that EGAL would have access to advertising space and should in the city of Hamilton. And so if the city is now having an unequal method of allowing advertising space, where it's vetting advertisements not based off of objective criteria, but based off of its subjective disagreement with the views of that advertisement, then it's actually creating inequality in the manner in which it's allowing people to use publicly accessible advertising space.
So as a I was going to say, Leah, as a standalone. You want to go, or can I? Okay.
Well, you go. We both have questions for you, Leah.
Well, as a standalone, this issue, this case as a standalone, is concerning for the reasons you've laid out, because it does have to do with whether the charter is a shield or a club. That's a big problem, how it's wielded and utilized. That's a significant problem.
Makes a difference
on its own. But this is not an isolated issue, right? This is seen in the light of. So I'm just drawing on just the last half a decade. This is seen in light of the passing of Bill C-4, calling historic Christian beliefs harmful myths and stereotypes. So that's that we can't see this separate from that. We also can't see this separate from Bill C-9, which is currently being debated in Parliament, which seems to be another step in the charter being used as a club against some when it's supposed to be a shield for all. So I'm quite concerned, even though on the surface from a distance this looks like some fundamental Christian group is not allowed to have their hateful, exclusionary advertising.
in one
that's how
city.
this
Who
is going to be played.
cares? Yeah.
In Hamilton, right in the armpit. Like this,
Yeah.
this looks like an insignificant issue,
Mhm.
but as seen as just one square in really the tapestry of the problem with hate speech laws, or the problem of how we define discrimination, or the problem of the infringements of rights and freedoms, as one square in this quilt of a growing kind of control of speech and infringing of rights, is very, very concerning. So as someone who specializes in constitutional law, how do you see this case not merely as being an issue on its own, but in this kind of wider picture of what we're seeing in the Canadian legal landscape? How is this, or how should this raise concern for Canadians in terms of where we are and where this is going, if the Christian Heritage Party is basically told, sorry, your beliefs have no place in the public square, in public advertising, and we're just going to take it down and there's nothing you can do about it?
Yeah, what legal precedent could this, though it seems like, as Andrew was saying, a very isolated case, what legal precedent could this set in our nation if this is able to, this decisions being upheld by the courts?
Yeah. So on the one hand, you're right. It does seem very niche and very insignificant. It's one advertisement from one city, in one instance. And even the city has kind of argued that and said, listen, it's one advertisement. Things could be very different if it was a different advertisement, right? So on the one hand, that's true. But on the other hand, you're right, both of you, to say, how does this fit into the bigger picture? And the important thing for me is the logical inferences, the logical end conclusions that are reached when we start from the argument here, the precedent, that it is okay for a politically biased municipal government to preemptively censor the political views of a registered political platform, and including one that has a sincerely held religious beliefs and is expressing a sincerely held religious views. But I mean, even just setting aside for a moment the question of faith and religion, and we do live in a very pluralistic society, so I think there are huge questions there, and I'll get back to that. But even just on the political front, if it's possible for a city to reject the advertisement of the Christian Heritage Party because it disagrees with its political views, why not the Green Party or the NDP or the Liberal or the Conservative? Do we really want to get into a context where whoever is in authority gets to shut down the political views of other parties that are smaller than it, perhaps, and decide and manage and regulate democratic discourse? And it's always easy for people to say, well, we're doing this in the name of safety, we're doing this in the name of protecting the public. But it's important to understand that free expression, according to the Supreme Court's jurisprudence, goes to the very core of the individual. There's no point having your own beliefs if you cannot express them. And so the ability, the court has used language like, there's no point in someone being able to shout on an empty street corner about its views. They need the ability to actually put up advertisement, to actually promulgate and perpetuate those views, disseminate them. And that's the way that democracy works. So I actually think this decision, and I don't want to be dramatic, and lawyers sometimes can go that way, but I want to be very serious and say what I see on the line here is fundamentally the way that our democracy functions. If it's possible for a government body like the city of Hamilton to unilaterally decide what can and cannot be part of political discourse in the name of something as kind of preemptive, and there's no evidence about harm in this case. The advertisement was never put up. And so if it's all preemptive and it's all just in the city's views, if that can occur, then I don't see how democratic discourse actually takes place in Canada. I don't see how the majoritarian view doesn't stay the dominant view. And it's important to understand that freedom of expression is about those marginalized niche views. The Supreme Court of Canada has been extremely clear that the ability to share a harmless opinion doesn't really matter. If your view is dominant, then you don't need the protection of the Charter. The Charter's protection is about ensuring precisely these kinds of views that aren't necessarily mainstream, that aren't necessarily welcome, are still able to be shared. And so we can duke it out in the court of, the arena of public opinion. And this is how democracy works. I mean, bad ideas are expressed all the time, and then they're addressed, they're ridiculed, they're picked apart, and other ideas are presented. And this is the exchange, the relationship that people have in the context of democracy. So that's an important point. I think fundamentally this threatens the fabric of our society. And I'll say also, there's been a lot of talk in this case about the dignity of the individual and the way that this ad, the city's argued it's discriminatory, and it goes to the very core of how a transgender person understands themselves. The Supreme Court of Canada has found that expressing one's views goes to the very core of dignity and equality, that at its core, Section 2B, freedom of expression, acknowledges that all individuals are equal. And because they're equal, they're able to express themselves and express their views. And then if they don't have that ability, then there's a threat to their equality and to their dignity in a free and democratic society. And so, again, if we're going to draw on questions of equality and dignity, we can have a conversation about those views, but we need to make sure that we're applying that not just to transgender people who are important and should have equality and dignity, but to also Christian individuals and women and other groups who might have very different views about these political issues. But then maybe to pick up on the thread you started drawing on, Andrew, with the question of religion, I will say that this is a concerning trend. I do see that there is a pressure, there is a pushback on views that are expressed from people of faith. And that obviously in this case is squarely individuals who are Christian, but this isn't only the Christian community. There are a lot of other faiths who would agree with Christians on this question. I imagine that the vast majority of Jewish individuals, Muslim individuals, Sikh individuals, and the list goes on, would agree on something like, a woman is an adult female. This is kind of a very simple idea that was historically accepted for a long time. And whether we want to accept that view or not, that's an issue to be duked out in the arena of public opinion. But we can't be preemptively censoring religious views because they're religious, because they don't align with the majority view. And so I think, Canada prides itself in being a pluralistic, diverse, multicultural society, and that definitely has its assets. But if we're preventing the diversity of views that comes from that multiculturalism, that comes from that pluralism, then you have to wonder, what's the point? If we're going to censor everyone down to one specific view and no others can express their disagreement with the government or with that dominant view, then what is the value of having that diversity if we're going to essentialize it and boil it all down? So we are having, one view, this is what it means to be Canadian, you accept this definition of what it means to be a woman.
Now, so I understand, for the divisional court, for the city, why they might want to downplay the legal significance of this decision, because, it maybe helps them in their argumentation say, well, it's more isolated. We don't have to get into the whole constitutional rights and freedoms of individuals. It's just, we didn't like the ad. We didn't want to run it in Hamilton. I get how that would do that. But certainly, I mean, they're not blockheads. These are legal professionals. They're lawyers. They're judges. Certainly they can, if Andrew and I can, as laymen, can understand the obvious legal and logical implications of what would happen if this decision goes forward. Certainly that can't be lost on them, right? They have to recognize that, this has actually significant downstream ramifications if we were to uphold the decision that, like you say, goes to the very core of, the jurisprudence on freedom of expression in Canada. I mean, that's extremely significant. And essentially, if I can understand where you're coming from, you're essentially saying, trans people have, under the charter, have a right to express themselves, and Christians also have a right to express themselves, and political parties have a right to express themselves, and that's actually what everybody should be allowed to do, and the government shouldn't be thwarting individuals in their rights to express that. But only one side is trying to do that, and that's not the CHP. That's actually the Hamilton City government and everything. So maybe talk a little bit of, obviously they have to understand this is a big deal.
Yeah, you're absolutely right, Matt. I mean, I think they understand it's a big deal. I respect the court and I respect the other lawyers. It's, we're dealing with intelligent individuals. I think this is really, again, at the risk of maybe sounding dramatic, this really is a battle over how Canadian society is defined. Are we defined based off of our freedom, or are we defined based off of maybe the safety and the shielding of harm that we bring? There's always a balance, right, to be between safety and comfort and freedom, right? Because when other people have freedoms, it means that I might really be hurt by your views. I might really disagree with your views. And I think there's always a temptation, especially when a group gets power, there's always a temptation to say, I don't like those views. I don't like having to deal with this. Let's just shut it down. But the reality is that the pendulum swings back and forth over the course of human history. And so if it's, what's good for the goose is good for the gander, that's the kind of, the typical thing people have said. And so if this is okay for the city of Hamilton to do in this current framework, the question is, what if in a hypothetical, there's a lot of Christian socially conservative people who take over as city councillors? Are they allowed to preemptively censor the views of groups that they say might create harm, that they say are not welcome and are insulting? It becomes a slippery slope. And I think you're absolutely right, Matt, that the solution to this problem, if the advertisement is problematic, let's take that as a given. I disagree, but let's take that it's literally problematic.
The dictionary definition of a woman is we can't forget that's literally what the ad is. But anyways, continue.
And one of the things we pointed out was that if this is the case, then every dictionary, every public library is insulting trans people left, right, and center, right? Like this, we have to kind of be reasonable here about what
Leah,
we expect.
Please, whatever you do, don't give libraries. Don't make a case for libraries to remove dictionaries and books like that's because if they're listening to this episode, what they're thinking is, hey, you know what? She's right. If we can preemptively keep these ads from going up, then I guess we can just get rid of that Berenstain Bears book that says a girl becomes a mom and has babies, and a boy becomes a man bear. We don't want to give them an idea to burn down the books and get rid of all the dictionaries. And I say that in jest, but the reality is you're right. Why is that not the logical next step? If the ad offends people and it compromises their safety, then I guess that means we should just get rid of every dictionary or every book that says the same thing, lest we harm our quote unquote transgender students. What an absurd proposition, but that is the logical conclusion of their position, is it not?
I think it's one thing that someone could argue, right? And is that if this is and they, like I said, the city did concede that this was a basic dictionary definition, and again, there were more explicit ways of saying this. The Christian Heritage Party could have said, woman, a biological female, a genetic female. There are much more direct ways they could have said this, but they were fairly gentle and vague, and they let individuals kind of think about it. And so maybe going back to your point, Matt, I think that insofar as this advertisement creates an issue, the solution is more speech. The solution is for the LGBTQ Advisory Committee or Egal Canada or the NDP or the Liberals or whatever other political or social group to start engaging in dialogue. If they really don't like what the Christian Heritage Party of Canada says and represents, that's completely fine. And they should be able to respond in kind and also have access to that public advertising space. And that's the way democracy works. That's the way that our society has worked. And so the concern here is that what happened wasn't a democratic discussion. It was a unilateral decision to preemptively censor one view in the name of protecting other people. But that becomes such a slippery slope because I don't think that the views of other political parties that I might disagree with should be censored because I might find them offensive. And so there is an expectation, a call to every Canadian to tolerate views that they disagree with. And if they really vehemently disagree, there are a lot of avenues for them to engage freely and democratically in changing society. They can run for office, they can put out their own views, they can have a blog post, a YouTube channel, whatever they like. So I just want to make sure that viewers understand, because there might be some viewers who really agree with the Christian Heritage Party and think good on them, that's the correct definition. And there might be others who really disagree. But if they do, either way, the principle here is we need to be able to have discussions. Because if we can't have discussions in a free and democratic society, then it's not a free and democratic society anymore. And that's why this case isn't just about the Christian Heritage Party. It's not just about gender issues. It's not just about the definition of women and women's rights. It's about who our society is, who it will be, the actual structure of our society, and whether we'll continue to be a free and democratic society. And so that really is what's at issue ultimately in this case. And so that's why it's an honor to be engaged and to fight. And we'll see what the Court of Appeal says.
So given the severity of the issue then, other than telling people you need to share this interview, you need to increase awareness and exposure, which we want to encourage people to do, which is why we wanted to have you on to discuss this, because we need to make this bigger than just about one bus shelter in one, smoke-filled, smelly city and one political party in the province, in the country. It needs to be, it's more than that. The implications are much more far reaching. So other than sharing, exposing, shining a light on it, what would be some other calls to action for our audience? What can they do practically, tangibly to either support this process, to share this out? Like, what would you offer to our audience to say to them, here's how we can help, here's what we can do in light of what's going on and the severe consequences if this doesn't go the way that we want it to?
Yeah, that's a great question. I would say first and foremost, these processes are expensive, and it is difficult. I can say from a constitutional perspective, constitutional cases often, and this one is more in the realm of administrative law, but when there are questions of charter rights, it's often very difficult for those who are trying to assert their rights to be able to afford that process because it takes so long, and cases sometimes, like in this one, go up to the Ontario Court of Appeal or maybe even the Supreme Court of Canada and other instances. And so that process is expensive, it's onerous, and for the arguments to be made clearly, cogently, coherently, for there to really be a strong legal defense, there needs to be a lot of time and money put into that process. So I know that the Christian Heritage Party of Canada is looking for support and has asked for individuals to make donations. I believe people can go directly to chp.ca/donate, and all of the information about donations are there. Because they're a registered political party, there are tax receipts, but then there are also limits on how much you can give. All of that information is available on their website. So I would encourage listeners to go to chp.ca/donate and consider making a donation. Again, whether you agree with the message or not, the principles at issue here are principles that will affect every person, every family, every Canadian. And then I would maybe say on a bit of a more abstract, esoteric basis, Andrew, I think I would encourage people to think really carefully and critically about how they engage in their own in expression in their own lives, right? Whether on social media or in real life. It's been said by someone wiser than me, said that I might disagree with what you say, but I'll fight to the death for your right to say it. And so this is the principle, is that we should be fighting for our freedoms and the freedoms of those around us to express political views, even views we disagree with. And so I would just encourage people to practice this. The way that we got here in society with this hyperpolarization, it didn't happen overnight. And so it's become the case that we reach to shut down and censor views that we disagree with, but that wasn't always the case. So trying to practice tolerance and disagreement in your own life is something that I would encourage people to do as well.
Well, thank you so much, Lia, for coming on the show. It's great talking to you, and we wish you God's blessings on your legal defense of the CHP, but more broadly, as we've been discussing, the rights of Canadians around this country to freely express themselves regardless of their opinions. So for all our listeners, we have a couple more questions for Lia that we're going to get into, maybe talking about, does the charter create a difficult circumstance for balancing these types of acts and rights and everything like that? So that'll be behind the paywall. So you'll have to become a paid subscriber over at ldcanada.substack.com to check out that question. But for everybody else, God bless you. And as we say at the end of every episode, it's for freedom that Christ has set you free. Stand firm, therefore, and do not submit again to a yoke of slavery.
Liberty Dispatch has been brought to you by SDG Media. If you want to stay in touch with us and all things Liberty Dispatch, join our email list, or support the show, head over to ldcanada.substack.com.